Howdy, howdy, howdy. Howdy, 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 howdy. It's Kurz here, and we are live coming at you with some crazy trial stuff. I don't know if anybody's been keeping up with current events, but a while back there was an awful event that happened where a man decided to drive through a parade in a van of some type or something like that, and unfortunately injured a lot of people and actually ended up killing some people as well. And this is the trial. It is live today. We are going to pull it back to the beginning because I didn't watch the beginning. I just kind of woke up, tuned in, and saw how ridiculous it was. I know I've seen a few videos about it, but when I say ridiculous, I just mean the conduct of and behavior of this man. Just a little background: this dude has been considering himself as a sovereign citizen. You can look that up. I'm not exactly sure the ramifications of that, but I do know that it basically means you don't follow the laws. And so that's basically his defense in this whole situation, is he's a sovereign citizen, but his behavior and conduct is that of somebody who believes they're always right, won't listen to reason, and
Wisconsin versus Darrell Brooks, case number 21 CF 1848. May I have the appearances, please?
County Judge Sue Upper, Leslie Basie, and Zach Witchell appearing for the state of Wisconsin.
I'm here as a third-party intervener in that matter, appearing as authorized representative for my client. I accept for value and return for value all of the charging instruments in this matter and make my exemption available for the discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments and make a reservation of all my rights here this morning. All rights reserved.
All right, good morning to you as well. The records reflect the individual known to this court as Darrell Brooks is present in person in custody. However, he is wearing street clothes, a suit and tie, and a mask.
For the record, I don't consent to being called that name.
It is noted.
Okay,
In this case, I do not dispute any of the facts in the charging instruments and make a reservation of all my rights here this morning.
what does that mean exactly? Is he saying he's waiving
All
his
rights
rights?
reserved.
All right, good morning to you as well.
All
The
rights
records reflect the individual known to this court as Darrell Brooks is present in person in custody.
I'm not very high in the law, but I'm not exactly sure what he's saying here. If he's saying he's reserving his rights, or if he's trying to make some kind of circumvent of the justice system here, but I'm not exactly sure.
Custody. However, he
If
is
anybody
wearing
knows,
street
they can
clothes, a
always
suit and
comment
tie,
right now.
and a mask.
For the record, I don't consent to being called that name.
It is noted.
So
All right,
for
Mr.
the
Brooks,
record,
just
he
preliminarily, do you anticipate calling any additional witnesses today?
For the record, I don't consent to being called that name. And what was the question?
Do you
Oh,
anticipate calling any witnesses today?
so he's got an issue with being called his name, I think.
I don't believe today.
Today?
Well, we are here for the continuation of testimony. The only witness that I'm aware of that's on your list that you added is your mother, Dawn Woods. So I would expect that if she's going to testify, she would be here. Otherwise, I will be going through the colloquy with you as to whether you intend to testify today or not.
Did you receive my ICS that I addressed to you?
ICS, not
Well,
sure.
I haven't looked. Let me look.
Let's pull that up. Figure out what an ICS is.
Actually, I just went to you and then went to the prosecution. Is the audio on?
It is. The audio's on.
In 1965, Jose Sierra founded the Impact Court de San Francisco,
Do you know when you sent
which
those?
was first court
Saturday.
of what is known as the International Court System, a
So that would have been
grassroots
the
network
22nd.
of organization and work.
State receive anything through, like, the inter-office communication?
We have not,
Some
I
kind of
just checked this morning to see if there's anything new. Nothing has been received at my office.
So
And I should
we
say
are going to do
the
some fast
clerical that was
forwarding some of
assisting
this
me
stuff,
went
but
to the
I
mail
do
room
know
to
that
double check.
if you haven't been
So not only
following
has it not
along,
made its way to the DA.
if you haven't been following along with the trial, the he's very interrupting. He interrupts a lot. I'm forgetting the word. Whatever. He's very disruptive. There we go. He's very disruptive in court. The judge has removed him multiple times, and today I believe he also gets removed as well.
A Brady claim should be visited because there were, in fact, recalls on that vehicle. In fact, there were recalls on the Ford Escape models from 2008 through 2010 in regards to the throttle body malfunctioning and causing the vehicles to accelerate and not being able to be stopped. There is a class action lawsuit where Ford company were sued because of this, and those vehicles models from the year 2008 through 2010 were recalled, and that is very important information in regards to the vehicle in question being a Ford Escape 2010.
So the Brandy Law in full, Brady Handgun Violence Prevention Act, U.S. legislation adopts in 1993, imposed an interim 5-day waiting period for the purchase of handgun until 1998. The Federation licensed dealers. I don't know if that's right. Just because he might be. It's some handgun violence. Prevention Act, not protection. Excuse me.
This information is very easily obtained just by pulling it up, and you will see a class action lawsuit. Obviously, if it's a class action lawsuit, then it's pretty easy to.
So what's your request, sir?
My request
What is the request?
To find out if Officer Schultz knew, to find out if the prosecution knew that there was a recall on those vehicles.
So he's basically saying he got violated. Sounds
in
like
light
he
of
violated his. He's saying
the,
they violated his rights.
The fact that these
They
vehicles
violated the
were
Brandy Law.
recalled
You can look that
because
up.
of this malfunctioning throttle body. For
Brandy, excuse me, not Brady.
I believe it's counts 1 through 73 to be dismissed.
All right, what's the response from the state defendant?
Thank you, Your Honor. As Trooper Schultz testified during his examination, consistent with our research, there are no active recalls listed for the Ford Escape. As Trooper Inspector Schultz noted during his testimony, that Ford listed an extended warranty for the throttle body on the Escape. The warranty was extended to 10 years of age and 150,000 miles. The Escape is more than 10 years old and has more than 150,000 miles. Also, he noted specifically in his report that he did not note any defect in the throttle body as previously described in this report. There was no recall in the throttle body. NHTSA did do an investigation into allegedly defective Ford throttle bodies, which would have impacted this year. Basically, the electronic throttle body failures would have resulted in engine stall or surge while entering traffic from a stop position or while driving at highway speeds, neither of which I believe occurred here.
So that is a very interesting point that I did not know that he brought up. I don't know the actual incident, so I don't know like how fast he was going or anything, but basically what he's trying to put forward, it sounds like, is that his vehicle had a malfunction at the time of the event, and because the vehicle sounds like was repossessed or recalled or something, he's trying to, no, it was recalled, that vehicle was recalled, and he's saying that his vehicle should have been recalled, but it wasn't, and I think that's what he's trying to get at, is it wasn't recalled, so therefore he's not at fault at this point, is what I think he's trying to say. And what the lady is obviously saying is there was no recall for his vehicle, there was no report for a recall for his vehicle, so that is irrelevant.
Further, Inspector Schultz would testify that that does not prevent the brake from working. So if this had been activated on this car, which it was not, but if it had been, and this defendant would have pushed down on the brake, it would have stopped the car. Further, if this was a problem, there would have been the malfunction indicator lamp or the wrench light would have been illuminated, as Trooper Schultz or Inspector Schultz testified when he started the vehicle and checked the indicator lights. None of them were lit. Further, if there was this, he would have observed material buildup on the commutator. There was no such buildup observed. There were no problems with the throttle.
Right. So basically,
electronic throttle.
We're going to get a lot of this in this case. A lot of him bringing up nonsensical points to try to get out of the situation he's in. I don't necessarily want to say believe. I don't think that's the right word. But I think that most people believe that he is guilty of the crime. It was, I believe, there's video footage of the crime happening, of him being arrested, all that good stuff. So, yeah, I mean, he's got to pull out anything out of his pocket right now to be able to try to get out of this one. It is an interesting point to bring up, I think.
Body, that was part of his report.
And more importantly, as it relates to this particular vehicle, based upon the testimony of Inspector Schultz, it's speculative as to whether this vehicle would be impacted, number one, by the class action, and number two, any throttle body problems. Because, again, there was a full inspection. That report was provided.
And I didn't say speculative. I think I used a different word. But, yeah, she's obviously going to one-up everything I say. I'm not a fucking law person. Excuse my language. I feel like I'm in the courtroom. I shouldn't be speaking like that. But, yeah, she knows what she's talking about, obviously. And it is very speculative. Like I said, it was irrelevant. That's what I use, irrelevant. It is speculative at this point, especially because there is a report that was put out for the car. So
it's basically, he testified on direct examination about there being no active recalls, and more importantly, he testified about what impact the throttle body would have and what he would expect to see if there were any issues with it. I am aware that the ICF, I did receive an email, it's one page with what you said. I have to turn my head, I gotta figure out how to flip it. So give me a second.
Okay.
Now have the ICF, the one for the state to be provided for the state.
All right, so here we go. He's going to get a little.
You have had this information for quite some time, either through counsel, except the state's offer proof as to what would have been the issues based upon the information provided. And again, without anything further from you by way of your offer of proof, I can't make a finding, number one, that there's a Brady violation, and number two, that the information you seek to cross-examine him on would have any impact
Brandy
whatsoever.
violation.
So I'll deny the request
Not Brady.
to dismiss the case, and I'll deny the request to recall this witness.
Your
Oh,
Honor.
it is a Brady
Hold on.
violation.
Hold
Excuse
on.
me.
Let me have the state just make their statement. I'll give you the last word on it. Go ahead.
The Inspector Schultz's mechanical inspection report was provided to the defense on April 29th, 2022. I noted that when the defendant was cross-examining Inspector Schultz, he did have the report in front of him, and it was asking questions directly related to information contained in that report.
All right. Go ahead, Mr. Brooks.
When you spoke to
So that's what he's saying. What she's saying is they both have a report of the actual incident of the crash or of the vehicle and the inspection, and he actually is saying that he's gonna, I believe, say he didn't get the full report, even though he made questions earlier in the trial. He does a lot of this. He does a lot of contradicting himself and just not helping him in his own case.
the owner of the vehicle, that's who gave me the information. My mother gave me the information of this. I had no knowledge until she told me. And that's how I came into the
Mama's boy, question mark? Mama coming into the rescue? I mean, every mama's got to save their baby boy. That's
information.
That's a
and
law,
she was
right?
the one that
Isn't that a
said,
law,
I'm going to
Mother?
send you all the information that you need so you can present it to the court. So I didn't.
I understand that, sir,
This
but
wasn't
your request
information.
is not timely. So you have had this information for quite some time, either through counsel.
I did not have it for quite
Let
some
me make
time.
my
It was
record.
just,
Either through
It
counsel.
was just told to me.
That's not what I'm saying. You've had the information about this report for quite some time, either through prior counsel or through all of the discovery that was turned over to you when you took over your representation of your own case. The fact that you have now learned this, it's a little bit too late. And I understand that may seem fair to you, but when I consider the information that you're providing to me.
And just for those people who find themselves in a similar situation, which I hope nobody ever does, or is in a law situation, this is why you probably shouldn't represent yourself, because there's so many little intricacies into the whole law game that is shown quite well in this trial, that if you think you're confident enough to do it and you're going to do it, you're still going to run into all sorts of little issues, little problems. Like, for instance, he found out this information a little bit later in the case and tried to bring it forth as evidence, but that is just not how the law system works. You're supposed to come into court, I believe, with all your evidence. There are some times where evidence does show up a little bit later. That always does happen. But again, you just have to be pretty professional, or it's gonna be looked at in the eyes of the public, in the eyes of the jury, in the eyes of the judge as kind of unprofessional, you know. So you got to be professional, and that's why I think it would have been in his best interest to hire a lawyer. But his whole complex that he's got going on probably wouldn't allow him to hire somebody to represent himself.
It's speculative on your part as to whether there's any impact on this particular vehicle because of the inspection that was done, and you had a full and fair opportunity to cross-examine the inspector about information that was readily obtainable and researchable by you prior to the time that you.
And that's exactly what I'm talking about. If you had a proper person or a proper lawyer standing by your side, this kind of stuff would have been looked into. Hopefully, if you have a good lawyer on your side, because that is public information. It's something that you're going to want to look into for this case.
You cross-examined this witness.
It was not readily available for me to expect at the time. I don't have access to the internet.
That's exactly okay. So this is exactly what I'm talking about. Bruh, that's why you hire a lawyer, especially if I don't have internet. Dude, just make all the excuses. The judge is gonna knock you down, bruh. That's why you had the opportunity to hire a goddamn lawyer. He's got internet. He's not sitting in a jail cell. He'll try to represent you to the best of his lawyer ability. And I think they have, like, whatever it's called, their code of ethics that they follow, you know?
How would I be able to?
Mr. Brooks, you're telling me your mother had that information.
No,
so,
I'm
and
telling
going to
you,
trust.
she just told me this information. I have the.
Again, the judge is not hitting the point here. The real point is you had the opportunity to represent yourself or have somebody represent you that could do a much better job, that has access to the internet on a 24-hour basis. And they would have found this information probably within the first 3 hours, you know, like
Phone calls to prove it.
I understand that. I'm denying the request, sir.
And I would like a.
So that's my decision.
I object to that, Your Honor.
okay. I object. My objection is going to make this a whole different. Bruh, this is ridiculous. Bruh, I object. He is so bent. He's so bent. He just cannot. I'm sorry, but this man cannot handle rejection, ridicule of his own beliefs. He can't.
I understand.
I
I've made my
object to that.
decision. I expect that you respect the decision, at least,
No.
as we're not going
No.
to debate it further.
No, I ain't
Yes.
gonna
I
respect
now
that
have
decision.
the
It needs to
ICF.
be.
No.
It
The
needs to
one
be
from the state
addressed,
that
Your
provided
Honor.
for the state.
It
Madam
needs to
Clerk,
be
I just gave
addressed.
that to you. All right, so
I
Mr. Brooks, in
respectfully
light of that,
object. I respectfully object, Your Honor, and
You-
request
you-
a legal reconsideration of your ruling, Your Honor.
You've already respectfully objected a few times now. So I think that's off the table. She asked you to respect her ruling. She respects your rejection, but she has overall say in the courtroom, I believe. At least that's kind of how the rules go, I guess.
it's
But-
denied. The request.
Again, I don't know. His whole sovereign citizen thing, I think, was denied to begin with. So he's being tried as an American citizen. But in his eyes, his objection is probably way more relevant and prudent, or it holds more weight in his eyes than it does in the judge and the public.
For reconsideration is denied. There's no legal basis for me to do
I
that at this point.
respectfully reject that ruling and take exception to that ruling, Your Honor.
All right, Mr. Brooks, we need to keep
Exception.
going.
For the record, may I request a legal or factual basis for your ruling, Your Honor?
For the record, he wants her to go in to depth, and he does this every time. He's gonna do this every time. Every time she objects, he's gonna try to prolong this. I mean, when you're obviously this man, he's sitting there in front of the judge. He's sitting there being judged. He obviously knows that probably the outcome's not going to be positive for him. So his last stint of glory, I feel like, I mean, this is my opinion, is that he's got to do everything in his power to stay in the relevant eye of the public for as long as possible. Every objection, everything that he's got to say is going to prolong the trial. That's basically, I think, his tactic here. Because there's really nothing else I think that he's got going for him besides the sovereign citizenship, which would have to create a whole sovereign citizenship uproar, and like many people would have to get behind this for him to even begin to be a sovereign citizen. And I don't even know if he like identified as that before the incident or not, or if he's just using that as an excuse. Because he's got a lot of excuses.
I provided an oral ruling today.
Let me take a drink real quick because I'm gonna have to fucking speak for 5 minutes to you again.
The record stands, sir.
For the record, may I respectfully request a written judicial finding of facts and conclusion of law on this issue?
Your request is denied.
Bro, she literally just told you all of the inner workings of why your ruling wasn't ruled. Like, she literally just went into it. I know I just said how he's going to prolong it, but come on.
Denied.
For the record, may I respectfully move for an interlocutory declaratory appeal of this matter?
So there we go with the big words. I feel like a lot of sovereign citizens really pride in their big wordage usage to really stumble and put a wrench in anybody's plan to legally put anything on them. But obviously he's in a heap of trouble.
I wouldn't be the one you would make that request to, sir. So I
For
can't
the record,
answer
ma'am,
that
move
yes
to
or
stay
no.
these proceedings until the instant matter is adjudicated by a court of competent jurisdiction.
That request is denied.
Based on what law or fact, Your Honor?
The request is denied.
Based on what law or fact,
What,
Your Honor?
any other requests, sir? I'd like to move on.
So I don't know if that's really legally okay to do. I mean, obviously she's the judge; she has say over everything, probably. But I feel like it for him to take the time. Just if you watch the rest of this, for him to take the time to actually respectfully ask for it could be given to him, just the explanation back, just so that he isn't. She is giving him more reason to be oh my god, I hate when I forget the word I want to use. It's so annoying. But it's like starts with an A, I think. But anyways, he's gonna get more agitated. It's not agitated I was looking for, but he's gonna get more agitated. He's gonna be more upset, and it's going to really make things harder for him. You know? Because if she just gave him the time of day and let him have his moment, I feel like he wouldn't be so ornery for the rest of the trial.
Based on what law?
There's no
Or
legal
fact.
basis that you've stated for me to do that, sir.
It has.
Okay, so there's no legal basis. He did ask for an explanation. I don't think there must not be any legal basis for her to give an explanation. She either has, it would be in her own interest to give the explanation at this point.
That's being, Your Honor.
The request is denied. The request is not a proper motion. There's no legal support for the motion. There's no factual support for the motion. So it's denied.
For the record, it appears that this court is acting in contempt of the law, Your Honor.
What? So again, for him to say that, he just says it. For him to say that, you can't really do that. You have to give some kind of explanation to what the contempt of law is.
Can you show me how or where this court is following the law of respecting this matter?
That's a very vague statement, sir. There's no legal relief that you're claiming. There's no motion before the court based in law or fact.
Which I think is an interesting segue to say that obviously all our laws are always changing every day, and I think that maybe that there might be a new law that comes from this just to make it so that people have the right to hear the laws, and if they don't know, to be explained during the court. So that would probably be like what is this dude's name? It's not a very memorable name for me because he's not a very likable guy at this point for me. But it would be like the Darrell law or the Brooks law or something. Something like that.
So this court cannot address that last statement of yours.
Your Honor, with all due respect, I would like a motion for finding a fact.
Denied.
Bro,
Under what law? Fact.
So he's literally keeps rehashing the same idea in different ways and different words, but she's already on to him at this point. He's not getting anywhere, and if he keeps it up, he's gonna get booted from the courtroom.
I made an oral ruling, sir. There's no requirement I do so in writing.
So you're denying a legal, you're denying a motion for finding a fact.
I am.
So
Yes,
how do
it's
I
you.
know what you're doing?
So again, there is a good point to this that I do want to. I'm trying to side with him on this, but let me also bring in the other point of the matter, and that's the fact that he represented himself. Again, it's his responsibility to know the law. It's his responsibility to know the proceedings, and he's about to say, well, how is this fair if I don't even know what the laws are? Well, that's what you signed up for by sitting there and representing yourself. So she is definitely more in the right, obviously, in this situation. I think so. But again, if she wanted the courtroom to be smoother and to have kind of that nice, not nice, but to have a more not respected, to have a more cohesive courtroom where everybody gets along, I think that it would have been smart for her to just allow that and just to say what he wanted to hear.
Doing this legal, Your Honor.
All right, Mr. Brooks, we're going to move forward.
She just ignores it.
At this time, I want to...
How do I know that this is legal, Your Honor? Can you show me that it's legal?
Mr. Brooks, we're moving forward.
It's not,
So-
this isn't law class. You're not in law class. You're in the courtroom at your own trial, and you're a defendant. You should know these things.
Your request is denied.
It doesn't seem
Mr.
like
Brooks, I need to give you some advisements, and I'd ask that you
I
stop
don't
interrupting
need your
me.
advice.
Damn. Damn. I don't need your advice. What you doing? I'm the judge here. That's like, come on, bro. Like, he's okay. Like I just pointed out, he feels he's going to be combative. Like I said, he's going to be combative.
No, I have to give you advisements, sir, regarding your right to testify.
I need you to do your job without prejudice and without
Mr.
bias.
Oh my goodness, bro. Like, I wish I could just... No, I can't. I couldn't be there. I would be kicked out. I'd be like, yo, bro, like, come on, dude. Like, obviously.
Has now interrupted me multiple times. He's failing to respect the court's oral rulings here today. It's something that he's done repeatedly throughout this trial. Mr. Brooks, I need to go through some advisements. Unless you have a witness to immediately call, I need to go through this particular discussion on the record with you regarding your right to testify. Do you have a witness to call, sir?
You don't need to go through anything with me on record.
Actually, I do.
Okay,
so.
So again, this whole thing is so obvious to me because he just went into like going off about like, I need you to tell me this information. I need this information. I need this information. I need to know this law. I need to know this. And then the minute she's like, I need to advise you, he's like, nah, I don't need it. I know what I need. I don't need what you got. Like, bro, you just asked for her advice about the laws. And now that she's going to give you advice, you're going to be combative and argumentative just to be combative and argumentative because you're pissed off that you're not getting your way. And it's so obvious. It's so obvious.
Sir, that is required by law.
Actually, you don't. You need to do your job as a public servant,
Mr. Brooks,
and honor the oath that you
I
took,
need to
Your
go through
Honor.
these advisements, and if you're going to
Jesus
keep
Christ.
interrupting me, you will forfeit your right to be present, and you
So
will
you're
be
holding me in
removed
contempt
to
again.
the next courtroom so that I can properly go through these advisements without being interrupted.
And I still don't have to answer. I still don't have to answer.
What is that supposed to do? Like, I still don't have to answer. I still don't have to do this. I still don't have to do that. Bro, are you trying to okay, he's trying to hold some kind of power over the judge at this point. Because she's like, I don't have to answer. I don't have to do this. This is my courtroom. So he's like, I don't have to answer. I don't have to do this because I'm Darrell Brooks. Okay? So, like, bro, wow.
Whether I'm in this court or not, so you're holding me in contempt yet again.
Mr. Brooks, I've not held you in contempt. I've found that you have forfeited your right to be present by your conduct, which is one of the options available to this court.
So holding somebody in contempt, I'm not exactly sure what that would look like in an instance like this. I think they would just send him back to his jail cell if he was held in contempt, and then he would be charged later for his outbursts in court if he was held for contempt. And the judge hasn't held him in contempt at all. She's been very patient and easygoing with the guy, but at the same time, I don't think she's going to give him everything he wants, obviously. And I think that's proper. But again, just in the eyes of like an outside perspective, knowing how things go, knowing how humans react with each other, I think that it would have been prudent to give him what he wanted, because at the end of the day, he's still going to go where he's going, no matter what he says or does in this trial, I believe. So just giving him that leeway would have shortened the trial immensely. But again, I don't know if part of it is just for the media attention. I'm not even sure. So
under Illinois versus Allen, under State versus Vaughn. It's also referenced in State versus Anthony. So I am going to keep going, sir, despite your protestations.
Your Honor, with all
I
due
need you
respect, in
to
Illinois
not
versus
interrupt
Allen,
me. This is another interruption.
In Illinois versus Allen.
Mr. Brooks,
do
I'm
they
not
say-
going to have a debate with you on
I'm
the
not
meaning
trying to
of
have a
Illinois
debate.
versus
I'm
Allen.
not trying to have a debate.
You
I'm
are
merely
advised
trying
that
to
it
understand
continued.
Illinois versus Allen.
Mr. Brooks, you are advised that
and he's about to get kicked out, folks. I guarantee it.
continued interruptions will result in you forfeiting your right to be present during this next phase of the
Do
trial.
you hear? Okay, I just want to point out she is very calm and collective, but you can hear in her breathing how angry she is right now. She's like, like you can hear it, bro. Like I would be pissed off too. Like, damn, she's holding it together.
Okay, but you saying that I'm
I've said
forfeiting
that
my
multiple
right.
times.
You
I've
saying
given you multiple opportunities
you're
to
holding
stop
me in
interrupting
contempt.
me.
You're holding me in contempt.
Bruh, Jesus Christ. She's not holding you in contempt.
Mr. Brooks,
Read the laws and figure out what contempt means. Stop saying that.
By
I'm not holding
removing
you
me
in
from the
contempt for
courtroom.
the second time here, and I've
Your
also
Honor.
repeated that.
Your Honor,
He's
with all-
interrupting
No,
me yet.
not by removing you. By removing you from the proceedings and not allowing you to have a say and not allowing you to watch the proceedings. Maybe you'd be able to watch it from your jail cell. That might be held in contempt, but you're not held in contempt. You're still proceeding in the proceedings. You still have the opportunity to talk, even if you're removed from the courtroom. You still have cameras on you. You still have a mic. You are destroying your own legacy here, buddy.
Again,
With all
Mr. Brooks, I
respect-
need you to stop talking.
With all respect, in Illinois versus
All
Allen,
right, Mr. Brooks continues to want to debate.
In all due respect, in Illinois, he just always brings it back, always, and now he's gone. Watch now he's gone. Now he's not gonna be in the courtroom anymore.
Debate with me the meaning of Illinois versus Allen. It is a clear indication to this court
trying to
that
understand,
he
Your
wants to disrupt these proceedings,
Right.
even
That's
in
not true.
mild manner, tone
That's
of
not
voice.
true.
I've
I'm
reminded
seeking
him
to
repeatedly
understand, Your
regarding
Honor,
standards
because
of
it
reform and
doesn't.
civility, and one of the
Illinois doesn't.
bedrocks is that he
Illinois
not
versus
interrupt.
Allen does not state.
All right, I'm going to
that-
remove him to the next courtroom so that I can go through
It does
proper
not state-
advisements with him without being
It
interrupted.
does not
We'll clear
state
the courtroom
that
and
you
we'll
can be
resume
present from
once he
cameras.
is over there.
It
Again, I'll make
doesn't
the
state
appropriate
that you can be
findings when
present
he is
from
there.
cameras, or that you could be,
Yes, we're off the record.
or that you
until,
could be.
he's in the
Okay,
other
so
courtroom. I'll
you're
be
making a
stepping off.
tacit
Thank you.
agreement for something that I.
They just cut him off. So I think what he was getting at is during another case, there wasn't what he's saying. There wasn't a law or like a ruling to where being in contempt or you could be held in. It's not. He's basically saying there's no law saying that being removed from the courtroom and watching the proceedings through a camera and talking through a mic, there's no law that's stating that that is legal, is what he's saying. But there's also no law stating that that's illegal or holding it in contempt. So he's just bringing up a mute point at this point, trying to disrupt the courtroom. Very clear. But yeah, this man is very, very disruptive.
Occasions do. I gave Mr. Brooks multiple opportunities to
Right, so
the subject matter. Have Don Woods available to call as a witness this morning. He's been unmuted though, for a while now. We can obviously hear him. I will ask Mr. Brooks a third time for the record. He's finally putting on the headphones. Is Don Woods in the courthouse?
I did skip a little bit, but I didn't watch it, but I know that he's just very ornery. He, at the point he gets into his other, just from watching other stuff, he's going to be very combative. He's going to act like he's above the court system, and he's putting on a show for, I don't know for who. I don't know, like, it just seems obviously I've already gone over what he's doing, but it's just sad, honestly. It's kind of sad.
Available to testify right now. Do you intend to call her?
Hold on.
What?
For the record, Mr. Brooks only puts on the headphones when he's in the other courtroom. He does not put them on when he's in here. The audio and the visual work just fine in that courtroom.
When I'm in the actual courtroom, I can hear it. I don't need to be muted.
Mr. Brooks's statements that the audio
That
doesn't
made
work.
no sense, bro. He said, when I'm in the courtroom, I can hear. I don't need to be muted. Those two statements do not coincide. Those two statements don't. One, you can hear in a courtroom doesn't affect the fact that you're muted in a different scenario. How does that even compute in your brain that you can hear in the courtroom so you don't need to be muted in this courtroom? No, you don't need to be muted in your mind so you can speak your mind, interrupt, and keep delaying the proceedings. Bro, you're gonna see. You don't even have. Sorry, but you're not smart enough to come up with ideas to prolong the proceedings.
I mute him is simply false.
I mean, he is prolonging the
I am
proceedings, but not.
Audio not working, so you need to stop.
He is prolonging the proceedings, but he's not winning. He's not doing anything for himself. He's just prolonging the proceedings, and that's really it.
I'm lying on the record.
I'm not lying on the record, sir. I
You are lying
confirm.
on the record.
All right, he is getting. I'm going to mute him once again because
Did you hear
now
that?
he's raising his voice.
Do you hear that? You are! You, come over here. Come at me. Like, he thinks his voice has got this power. And I mean, voice does have power, but when you're in another courtroom and she can hit a button to mute you, your voice is virtually powerless.
Voice. Now he's angry. He's thrown the headphones. He certainly does not seem to want to answer any of the questions this court has. I asked him 3 times if he had any additional witnesses to call. I warned him that if he did not answer that question, he would forfeit his right to call additional witnesses, other than perhaps himself. I then specifically asked him about Dawn Woods, because that is the person he indicated he wanted to add to his witness list last week, and I granted his request to do that. I asked him twice. He did not respond to that. Based upon his failure to respond, based upon this court advising him that if he failed to answer that question, he would forfeit his right to present any additional witnesses, again, other than perhaps himself, I'll find that he has forfeited his right to present and call any additional witnesses based upon his conduct in this case. I would direct...
See, you hear that, he's been basically barred from a lot of his rights at this point because of his outbursts in the courtroom. So that does come up a bit later.
I'm aware that he's able to read and write English. I would refer back to the record made during my colloquy with him regarding the waiver of counsel and his ability to be aware of rights, his ability to... I made a finding at that point.
All right, let's move on. So it gets, I don't know, the middle part, there's some you can watch the whole thing, but there's some witnesses that come forward, the defense or the state asks some questions. He asks a couple questions, but it doesn't really get anywhere.
Provided with a written copy as well, again.
So wait, hold on, I don't know. I want to get to this.
And corner you.
Alright, so it is right here. So he's gonna go on. He's been basically, I don't know if he's done it yet, but he's gonna ask again with his rights. Which, mind you, he just like we just heard, he did forfeit his rights because he was some of his rights because he was being disruptive in the courtroom. So those rights he doesn't really have, and he's gonna dispute that and argue that for quite some time. Try to dispute it and argue it until he gives up. And again, I just don't give up, bro. Never give up, even if you're doing something stupid. You might as well go all the way. I don't know. That's probably not good advice. It's probably terrible advice. You probably should follow the law and
Sure.
like actually do the proceedings.
You are in the meeting now.
So there was
I need to get the other courtroom in, so just
hold
so I
on.
can get the email.
So they're just getting some.
Your request is noted.
Honor,
All right,
It's
here we go.
denied.
Here we go. So he obviously has been disrupted the whole time, so I think they took away some of his privileges. I'm not exactly sure, but they needed to pull up another slide or Zoom call to pull up the slides that are in the actual courtroom so he can see them on his computer. So that took a minute, and now he's going to try to dispute his situation.
Okay, thank you, sir. I'll stop sharing. Okay, thank you, Zach. You can step down. All right, I just wanted to put that on the record since that was an issue raised by Mr. Brooks previously. Now, I need to get a copy of the jury instructions. They were quite lengthy. The record should reflect that Mr. Brooks was provided with a written copy. It's 107 pages, and the state was provided with a written copy.
And Mr. Brooks, she's going to say it, but I want to say it before her. He gets the paperwork, 107 pages of their, like, what they're supposed to do, the jury. I'm not exactly sure. Their jury proceedings or delivery or whatever. And they're all supposed to read it, and he just threw it in the trash can.
As well, again, it's all the same 107 pages.
So again, he's trying to show power, that he has power over the situation, that everything they're doing is wrong and not right, so he doesn't even need to like look at it or like put interest in it, because he feels like if he doesn't put interest in it, that's going to put some kind of power over the situation for him, and where it's not as credible, I guess, is what he's trying to get at, I believe. But if you do that and it fails, then you don't have any of the information that you need in that proceedings. You don't have any of the laws or what is going to happen to you, because you just threw it away and were ornery and didn't want to actually read what was there. So I believe probably that's going to come up later for him, where he's going to try to argue these facts, but he had the information he needs and threw it away because he wanted to prove a point or whatever.
And then my written copy is on its way.
I set the value, return the value each document. That's if I'm not muted.
You're not muted.
I also would like to again ask for subject matter jurisdiction to be proven on the record.
Your request is
That
denied.
has yet to be verified. It has yet to be
So
verified.
again, he found out that he's not muted, and he goes right back into these ridiculous objections to the proceedings, and she just denies it, which only frustrates him more.
Your request is
Your
noted.
Honor,
It's denied without further hearing or consideration.
Without
I
further,
was just told
so again, that's why we played the beginning, because that does sound kind of like, if you just pull that out of context, it doesn't sound like it's really right. It sounds like the judge is being unfair, and that's what he's trying to make it seem like. But again, he put himself in this own position by being ornery, by not listening, by saying, no, judge, you're wrong. Like, nah, I'm not going to listen to you. Nah, fuck you, like, kind of attitude. And that just blew, like, that's going to come back to him right here. It's going to bite him in the butt right here.
that the evidentiary phase is supposed to be closed. How come I haven't been able to present my evidence into the record as I've asked numerous times on the record to be able to do? I've said I have numerous documents that needed to go into the record. Why have they not been permitted to be made evidence?
So again, he forfeited his right to proceed in the proceedings as a normal lawyer would be able to. And she'll go into why he's not allowed to, but again, that's number one reason. He's already forfeited these rights, I believe.
I didn't rest my case, so I don't know why that's being told. and I have yet to be able to offer my exhibits into the record for evidence. How is that so, Your Honor?
She's gonna tell you, but she already looked over the evidence, so that's why.
So the court did declare the evidentiary phase of this trial closed. I specifically found that you forfeited your right to present any further evidence or testimony when you failed to answer my questions regarding the calling of witnesses. And then I also declared that you forfeited your right to testify. Specifically as it relates to your trial filing, sir, I would note that all evidence in a trial must be proper, it must be probative, it must be relevant, and it must follow all rules of procedure and all rules of evidence. To the extent that you wrote all of those documents, sir, that would be hearsay. And for that reason, I'm denying your request to make them
That's
part
ridiculous. The man's pulls out all this paperwork. I don't know. He's got stacks of binders or boxes of folders of paper. I don't know if he wrote all that himself. But apparently he's written a bunch of evidence that he wrote himself to further his case, which is not how you present evidence. Obviously, evidence is based on facts and proof and all this other stuff.
of the record.
They were not hearsay, Your Honor. I did what you told me to do.
So again, he's just gonna argue this. They are not hearsay. Again, I did what you told me to do.
You told me since I was representing myself pro per that I had to write everything out.
I would represent myself pro per or pro bono. I don't know.
And present it to the court.
So that's
so he's saying I was supposed to represent myself and present it to the court, and she's gonna say that's not
not what I said. You're misquoting me, but
that is not necessarily how the proceedings work. Again, you have to provide the right or the facts that you have in the right channels of the law. If you're going to proceed in the proceedings of a courtroom, you have to put that evidence in the right hands, in the right channels to actually be put forward as evidence in a courtroom.
in any event, I'm denying your request. I said.
So you're saying that I have no right to present evidence and to have exhibits as the state's been able to do.
Mr. Brooks, I'm not going to have a debate about this now. I gotta mute him once again. Right? So, Mr. Brooks, I have mute.
Bye-bye. Get muted, bruh. I feel like he's gonna feel like this is like his ex-girlfriend or something. Like, you ever get those phone calls where you're having an argument, you feel like you really want to say something that you know the point of, and then you just get hung up on, and you just get muted. That's the situation Darrell Brooks is in right now.
Muted you because I declared the evidentiary phase of this trial closed. You forfeited your right to present further evidence and testimony.
Look at him get angry.
Previously by refusing to answer the court's questions. I will specifically address the filings.
The thing is, he's got this complex inside his head where he believes the things he's saying are actually right, I feel like. Because look at this face. Just look how determined he is to, say that you're not giving me my proper rights, And he's obviously a little bit delusional at this point because of the fact that he is in a courtroom. He's in the courtroom, and the courtroom is owned by the judge. And for him to, act like it's not, it's kind of delusional.
Number one, it is not true that I advised him that any filing would be...
Even in the laws of, the laws of laws, even if this isn't right for Americans, and it might be proven thousands of years from now that this kind of shit is wrong, but even in that case, Brooks is still in the wrong here because he's proceeding to be combative to somebody, even in a normal conversation with your own peers. This kind of behavior you would want to walk away from. You wouldn't want to engage in because there's no your side in talking to somebody that has everything figured out to the point where they're not even going to listen to what you have to say. And I'm sure Brooks in this scenario feels the same way about the judge that the judge is doing what he's doing, which is kind of gaslighting him, the judge, but also gaslighting himself to not realize the situation he's in, if anything.
Evidence. That is simply false. Number two, filings, I told him if he wanted to present motions, should be written down and should be based in law and fact and request specific relief. I'm well aware that previously he has referenced he would like his filings made exhibits. I've reviewed those filings. There's nothing relevant, nothing probative, or the information contained therein is hearsay.
So again, that's pretty bad. If that's true, like, and his stuff is irrelevant, there's nothing that's probing any questions that have been forth put, and the rest of it is hearsay, which means he's just basically saying things in his favor that nobody else has any fact or basis on. And that's what he's trying to put forward to the court. It's kind of child's play. Like, that's... if you're going to represent yourself, you kind of have to know this kind of stuff, right?
Mr. Brooks would have needed to testify regarding any statements that he, from himself, testimony. He cannot simply put in an affidavit. That's not proper. That's hearsay. And he hasn't asked in any of those filings that he hasn't put forth any exception to the hearsay rule that would allow this court to admit his written filings.
Mind you, she is taking her time to explain this to the courtroom, and maybe to him, but they are already supposed to be on to the next part of the phase, which is the jury papers. Remember I mentioned that he had 107 pages? Well, he's just he does not want to get into that until he gets to be heard. Is basically his whole stent here.
I believe, without fail, they are all irrelevant, not probative, and hearsay, and therefore not admissible. So we're moving on to the discussion of jury instructions. When Mr. Brooks wants to abide by the rules of decorum and civility, I will unmute him. He clearly just took the entire packet of jury instructions and put them, I don't know what's under the table, if it's a garbage can or if he just simply put them under the table, but they are no longer in front of him.
Which is not
I will,
doing anything.
however, unmute him so that we can get his feedback regarding jury instructions. It's typically a back and forth. We'll go through them.
And nobody's really read anything on the juries, I don't think, yet, but yeah. He definitely hasn't read anything because he just threw them on the ground. So,
And
I don't know how helpful
I'll
that is.
ask the parties whether there are any instructions they believe should be included, and we'll have a discussion on that, and then we'll talk about whether any of the instructions that are in here need to be modified in any way, taken out, edited, etc.
Beauty.
All right, you're unmuted now, but you have to not interrupt.
No, you can't, I'm not trying to interrupt.
Nah, bruh, the first thing he does is interrupt her. Nah, nah, you can't do this. You can't tell me that I have no rights, even though I'm the one that took away my own rights by arguing in earlier trials. No, you can't do that. You can't.
How can you deny me the chance to put on the adequate defense by saying?
Because you forfeited that right by arguing and being a total asshole in court and being an asshat and looking like a fool. That's why. Can somebody just say that to him? Can somebody just tell him he's an asshat?
Nothing that you told me to do can be presented into evidence. So you filed them. You filed everything that I gave to you. You
All right,
filed.
Mr. Brooks, I'm
And
going
that's
to
all I'm
mute you
saying.
because this is not relevant at this time.
It is.
He's
Bye-bye.
raised tone of voice. He's very animated. He threw the jury instructions on the floor. I understand you're upset, sir. I understand you believe I'm violating your right to present a defense. I've made my rulings. I determine you forfeited your right to testify, which includes the right to present evidence as you would have testified. I closed I closed off your ability to call any other witnesses by finding that you forfeited your right to do so based upon your conduct. I understand you're frustrated. I understand you believe that I'm not without authority to do that. I made specific factual findings. I've referenced the law, and you being upset with the decision is not going to change my mind. He's also taken the headphones off.
So
it's
again,
his choice right now whether
those are his ornery ways of showing denial of the situation and trying to take control of the situation by taking off the headphones, which makes it so he has no idea what's going on in his own trial. So in my opinion, at this point, he's given up on his own trial, and yeah, he's given up right now. He's given up.
Participates in this jury instruction conference. It is his choice. But if he is going to spout off about things that I've already determined, I will continue to exercise the mute function on the audio equipment. I'll unmute him again, but you are advised, sir, you need to be
mind
proper.
you, she's talking. You can hear. I can hear her. He cannot. He has no idea what she's saying right now because he took off the headphones. And she's probably very aware of that. But she's still being a good, judge, a good person, even. And actually, is still giving him, chances to.
You need to not interrupt,
kind of.
and you need to stay on task, which is we're discussing jury instructions, not other evidence, not subject matter jurisdiction, not your belief that I told you to file things a certain way. We are now discussing jury instructions. So once again, I'll unmute him to see if he can follow these simple rules.
You need to tell me why I can't present evidence. How can you deny me the...
Bruh, again, he's gone. He's not there. He's not at the trial. He is in his own world where he's been denied his rights. There's nothing the judge can do to stop it.
How can you deny me my rights?
But again, I for her, if she really did want this not to happen, she should have explained why. She should have explained earlier what was going on and why he's just not allowed to. The laws. She should have explained the laws, even though it's his right to know the laws. Or it's his responsibility to know the laws. But yeah.
Present evidence.
All right, I'll mute him once again because he wants to continue. And again, I understand he's upset. I understand that.
Listen to the like giving him the benefit of the doubt. Still, I understand you're upset, sir. Still trying to calm down the situation.
But he has himself to blame for his conduct this morning and the rulings that I've made. All right, so let's go through these jury instructions. First of all, has the state received a copy of the draft?
Yes, Your Honor.
Thank you. Mr. Brooks, do you acknowledge receipt? I believe you did by acknowledging it previously, but do you acknowledge receipt of the draft of the final jury instructions?
I didn't acknowledge nothing, and I don't acknowledge anything now. I have not received anything.
I would ask the bailiff to pick up the documents from the floor and put them in front of him.
And I'm not presenting it to nothing I don't give my consent to. You can't deny me the right to put on the defense. How can you tell me when I just stated?
I'm going to read it once again because again I understand he's upset. If the bailiff could confirm, well, he put him on top, he put him on the floor. That's his right. They're not in front of him, but it's by his own conduct that he's done that. The record should reflect Mr. Brooks is muted because he wants to continue to debate with this court about my prior rulings regarding his forfeiture by conduct of his right to present further evidence on his behalf.
Right. And as you can see, what else are you going to do in this situation?
I know one of the things I probably need to look at, I'm not sure if Madam Clerk did this or not, would be the language from the amendment from the amended information on count.
But as you can see in the way he's acting that he has given up. He has given up, and I mean, the trial was over before it began, but the trial is over, in my opinion, right here. When he gives up, it's over. The judges can see, or excuse me, the jury can see if they're there. I'm not sure if they're there, but they'll be able to see this kind of behavior. It's not going to work well in his favor, obviously. The evidence is probably substantial that he did commit this crime. So, he's just giving up. You can see, like, yeah, like, what am I supposed to, like, there's no point. I'm done. Like, I'm out of here. He's probably going to want to go back to his jail cell. Guarantee you, though, she's not going to let that happen.
The 76 count. Just want to make. It says near Frame Park, so it is in there.
I don't know why.
That was just one question I had.
Little disclaimer, I know that she's going to not allow him to go back. But
State have any requests as it relates to the jury instructions?
I don't know exactly why they wouldn't.
I'm just going through each one. I'm on page 50 of 107. Everything's looking great so far.
Okay. Fair enough. There's 107 pages. I certainly can give the parties some time to continue to read through them.
And they're going to read for a bit, but right before that, we're going to see. He's packing up. He's ready to go home. Bring him back to his cell. Can't even see him. He's hiding. He's hiding behind. There was another day in this trial where he showed up in his jumpsuit from jail, the orange jumpsuit, and he got kicked obviously into the other room again in that proceedings, and he decided to take his shirt off and face the wall, and that's how he was acting that day.
Mr. Brooks is requesting to go back to his cell. At this point, I'm going to deny that request. He can remain in the other courtroom.
So he's trying to go back to the cell, but she denied it. She's not letting him go back. He needs to stay for his own demise. They're going to do a bit of reading.
Just want to make a continuation.
She clears her throat. She's ready to get talking. Chico. And by the way, for people that want to know my personal life, I have officially made a full change to my name. So now it's more the root of who I am. My full name, well, I'll not tell the full name, but my first name is Kurz, by the way. Just thought you should know that. That's why I'm Kurz.
I just want to make a continuing record that Mr. Brooks is still, I can still hear him even though he's muted due to his level, his tone of voice and volume level that he is using from the neighboring courtroom.
She can hear him through the walls, it sounds like. Wow. This man needs to go to jail. He sounds like a danger to society. Well, he is a danger to society from the evidence, allegedly. But yeah.
Jumping.
spots that either in the headings have some information or words that might need to be removed.
We're just gonna go into the proceedings. That
I believe that those were add-ons at the end that the court wanted to question the parties about.
Yes.
I believe that there was 325 should be given. One of the witnesses for the state did testify. He did have one prior conviction. I believe a witness for the defendant testified that he had a number of convictions. With regard to that same page 106 of 107, instruction 141, where identification of defendant is an issue, I don't know if it is an issue. That wasn't raised during the defendant's closing arguments. His opening arguments. I would know that, or note that.
so that what they're talking about is the fact that he has denied his name is Darrell Brooks, and they have to raise that as an issue, I guess, because he's made it an issue, but he didn't start off in the trial with that issue. He kind of made it an issue later because it worked in his favor at the time, and they're pointing that out.
The defendant would sometimes cross-examine people on if they were able to see the person driving or the description of the person driving, and he would cross-examine them as to their ability to perceive that. So I guess that would really be up to the defendant if he wishes that to be given. On page 107 of 107, instruction 172, circumstantial evidence, flight, escape, concealment, the state that was included in the initial instruction that we requested, and I would continue to request that instruction be included.
It's really just flight, though.
Correct.
What's that number again?
172.
I'm not exactly
I know,
sure.
it's just not there.
They're just going over the rules. Okay, here we
Because
go.
I've confirmed previously regarding the audio working, and I will just ask him a second time, sir, do you have any requests as relates to the draft packet of jury instructions, whether that be any additions, corrections, edits, or deletions?
And if he goes in to his rights again, it's been, I know I skipped, but it's been like a good 30 minutes almost of silence. Maybe not that long.
Your Honor, would it be possible for the bailiffs to just move the boxes off the table so
Yes,
we
I
can
think
see?
that's fair. I'm going to advise the bailiff to remove the box so I can see Mr. Brooks. I don't.
Jeez, hold on just a sec. I do want to see this. I haven't seen this part, so I'm gonna pause it. We got Jumputi on the left side. Check it out. I'm just grabbing a snack. I'll be right back. Out of here.